Hello, everyone. Welcome to tonight's virtual panel discussion focused on the need for sentencing reform in our criminal justice system. This is the fourth in a series of 8 virtual panel discussions that are hosted by Nebraskans for Prison Reform and Stand-In for Nebraska. These panels are scheduled to occur on a bi-weekly basis, and we will be continuing on until about mid-October. We hope that you will join us for the remaining panel discussions that are focused on issues related to parole, reentry, restorative justice, and community activism. My name is Dr. Brashani Reese, and I'm a public speaker for Ending Life Sentencing, an advocate for restorative justice practices, and I am your facilitator for this evening's discussion. A few logistics before we begin. As an attendee, you're going to notice that your sound and your video is automatically muted, but feel free to utilize the chat window and the Q&A feature, both which can be found at the bottom of your screen for any questions that you may have. And if you're experiencing any technical difficulties, please private message our Zoom host, Ashley, from Nebraskans for Prison Reform. You also may have noticed that tonight's conversation is streaming on Facebook and it's being recorded, which means it will be available for future viewing. Without further ado, please allow me to introduce you to our esteemed panelists for this evening's discussion. We have with us tonight Alex Bailey. Alex is a strategist for ending life imprisonment at the Sentencing Project, which is a national research and advocacy organization located in Washington, D.C. Senator John Cavanaugh from the Nebraska State Senate. He represents District 9. Attorney Tom Riley. Attorney Riley has been the Douglas County Public Defender in Nebraska since 1996. And Attorney Jeffrey Ellis. Attorney Ellis worked on the case of the matter of the Monschke case in Washington State, which recently made headlines this year, which utilized the foundation of the Miller v. Alabama case to provide further sentencing court discretion for cases up to under the age of 21 years old. A warm welcome to you all. Thank you so much for being here with us. Each of our panelists will have about 10 to 15 minutes to speak, and we will close out tonight's conversation with a Q&A session. Feel free to drop your questions into the Q&A or into the chat throughout the discussion. I will be facilitating and moderating our questions as we go along. So as we begin, let's set the stage a little bit for tonight's discussion. One of the reasons that we are here talking about the need for sentencing reform is because although mass incarceration was created by large numbers of our citizens being funneled into the prison system over the last 4 decades, the issue of mass incarceration is perpetuated by the lengthy sentences that are given out, specifically life sentences. 1 in 7 incarcerated people are serving some form of a life sentence. In fact, our country's lifers population is now greater than the entire prison population in the 1970s, totaling to more than 200,000 people. First, let's address the elephant in the room. There is a myth in our country that releasing incarcerated people who have committed violent acts in the past is a threat to public safety. In actuality, there is ample scientific evidence that refutes this. Research has consistently shown that it is quite rare for people who have served lengthy sentences for homicide to commit another act of violence after release. I want to give just a couple of specific examples from the Sentencing Project's report called A Second Look at Injustice that was issued earlier this year. And this report is available online, as well as all of their publications are, and I'll drop a link for that a little later. There was one study in particular that looked at individuals in New York and California who were 55 years or older when they were released, and they were imprisoned for murder or manslaughter. And when they were released back into the community, only 0.2% were re-imprisoned for the same offense. Another example, in Maryland, 188 life-sentenced individuals were released following a 2012 court decision. Only 5 of those individuals were reincarcerated some of whom of the 5 were actually for parole violations, not for further violent offenses. Again, that's approximately about 0.2% recidivism. Now I'm going to stop because I don't want to spoil it all for our panelists. And I'm going to turn the mic over to our first panelist, Alex Bailey from the Sentencing Project, to go further into this discussion. Alex, the floor is yours.
Well, thank you, Dr. Reese, and thank you very much to the Nebraskans for Prison Reform for inviting the Sentencing Project and myself to this very important discussion. I think that it couldn't be more timely. We are watching a second look legislation being either suggested and or introduced in legislatures across the country, because what we know now about brain science, about recidivism, about crime in general suggests that the trend that this country has taken, our reliance on mass incarceration, has led us to disparities that are trending in a way that is most violent, is most disruptive to our society, to our stability, and frankly, they just don't work. What we know is that long and lengthy prison sentences actually do not decrease crime. We do not see it even having an effect on, the death penalty doesn't even have the deterrent effect that people seem to think that prison will provide. As Dr. Reese said, it doesn't increase public safety. And so what we have to start looking at is new tools and mechanisms for release. The Sentencing Project's recidivism report, which was released not long ago, actually displays, and I'll put this in the chat later, that those who are serving for what we would consider violent crime, first and second degree murder, so on and so forth, are actually the people least likely to recidivate. And I think that's worth repeating. The people who have committed violent crimes, what we consider first and second degree murder, are the least likely to recidivate. What we also know is that the average criminal career is only about a decade long, with many people who are serving having perpetuated their crime under the age of 27. What we now know about brain science says that we do not have a fully developed brain until we're 27. And it is time that our legislation reflects our scientific knowledge. To do so, at least in my mind, is to willfully be ignorant in our policy. Which is completely unacceptable. We see a lot of bills that are being introduced for the age of under 21. It is my personal opinion, and science backs that actually does not go far enough. And because of the lengthy sentences that we have been sentencing people to, that, as I said, are not effective. In a state like Nebraska, 27% of the prison population are elderly lifers, which the Sentencing Project defines as people who are 55 years and older. There are 970 people as of 2020 in Nebraska who are serving life or virtual life. And this is spread across demographics. All of the stereotypes about who's in prison and why don't hold up, not just in the state of Nebraska, but across the entire country. 35% of the people in the life and virtual life population are Black or African American, 47% would be identified as white, and 13% would be identified as Latinx. So what we see is that this is cutting across the whole swath of the community in the state of Nebraska. And with 11% of the population serving virtual life, which is a sentence whereby you are not specifically sentenced to life without parole, but the length of your sentence is such that your natural life will be served in prison. So you might hear of sentences like, 60 years plus 25 additional years for 3 other charges, right? You won't survive that time. So that's what we consider a virtual life sentence. So in Nebraska, 11% of your prison population are serving a virtual life sentence, right? Which tells us that which often tells us that the way that we're working in terms of sentencing is incredibly disproportionate. And that rather than simply call it what it is, a life sentence, they're trying to get around it by sentencing people to draconian sentences that obviously, will be beyond the scope of their lifetime. And the difference historically that we're seeing is simply staggering. There's a 97% difference in 2020 to the life sentence population in the state of Nebraska versus your 1970 population. That's really an incredible number that I think everybody sort of really needs to absorb. And like I said, this cuts across wide swaths of your community, and it doesn't make us safer. And I know the thing that everybody is going to say is crime rates. Crime rates are going up, and everybody is concerned about that. I think we need to be very careful about how we think about this, because it turns in our society into over-policing, which then leads us to this terrible reliance on mass incarceration. So what often happens and what you often read in newspapers is that crime is going up, but actually the long-term trends in crime are more accurate than a year-by-year basis. So what we actually have to look at is the broad swath of history when it comes to these things. And what we know is that crime is actually trending downward. But the more that we see economic disparity, a lack of education, a lack of intervention for addiction and mental health, will continue to start to trend in a way that will increase violent crime. And these are actually the things that we need to address, as opposed to relying on prison sentences, which in my view are completely inhumane. They don't allow people to return to society as productive citizens. I've had the pleasure of meeting so many people who have served sentences, who I know that if they were released would be the kind of neighbor that all of us would want. And more than that, I think that they are the type of people who can help us to address way downstream the things that we're now seeing in terms of our prison populations. As somebody who's a survivor of violent crime and domestic violence, I don't come at this from a cheap seat. I very much understand people's concerns. I have lived those concerns, but I know for a fact that my decisions to not take the incarceral route have actually served myself and my society more than leaning on those things. So I think I've gone on quite enough. And I will cede the floor to our other panelists. Thank you, Dr. Reese.
Thank you so much, Alex. And no, not at all. First, I just want to say thank you so much for bringing your personal story into this space. Sometimes when we're having these conversations, we can really get, heavily focused on the data. And this is just a reminder that justice is personal. This would not be as controversial as it is if justice wasn't personal. And if as a country, we weren't trying to come together to try to figure out what does justice really mean for us. Because in these spaces, we're saying it does not mean this draconian idea of an eye for an eye, of a life for a life, that there has to be some form of justice beyond that. So before I get onto another tangent, I would love to turn the floor over to Senator Cavanaugh.
I have to unmute myself. Well, thanks for having me, everybody. Thank you, Dr. Reese, for the introduction. And thank you, Ms. Bailey, for the kind of, I was sitting here thinking with the same thing that Dr. Reese was talking about, is that there's a lot of data out there. So my perspective that I come from, so I'm a senator in the Nebraska legislature, but before that I spent 7 years working for Tom Riley in the criminal justice system as a public defender. And so I've been in the legislature for 90 days, and you've got me tonight because Senator Pansing Brooks had a family emergency. So you get the poor man's Patty Pansing Brooks tonight. But I worked with Senator Pansing Brooks on a number of the bills that I think are relevant here, including LB 34, which of course kind of parallels, I think, probably what Mr. Ellis is going to talk about. which is changing sentencing for individuals under the age of 21 in the state of Nebraska. So we've obviously, I think Mr. Riley can talk a lot about resentencing for juveniles after the Supreme Court decision. I think it was Miller. Is it Miller v. Alabama, Tom? Is that it? Yeah, okay. And how Tom has done a bunch of those resentencings and folks who shouldn't have been incarcerated for life and then ultimately got a reduced sentence. And so what LB 34 does is essentially extends that age to the age of 21 and says that it recognizes what the science recognizes, and recognizes really what anybody can tell you anecdotally, is that anybody under the age of 25 is not an adult. They don't understand the consequences. They don't react to the world in the way that you want them to. And we are sentencing them as adults, and we were previously sentencing people younger than that as adults. And so what Senator Pansy-Brooks' bill seeks to do, and what hopefully we will accomplish, is going forward, we will say individuals 21 and under are not adults, and we should treat them differently. And there's a number of reasons for that I think that Ms. Bailey kind of hit on, which is that, in my mind, and I'm sure that this is, I guess, what do you call it? The historical research will tell you that the arguments for the criminal justice system are to divert people from committing crime, to rehabilitate people, and for punishment. And when you incarcerate young people who aren't rational, who are not responding to those stimulus appropriately for the rest of their life because of the actions that they took when they were young and unreasonable, it only serves the punitive aspect of the criminal justice system. It doesn't make society safer in the long run. It doesn't divert them from committing those crimes, and it certainly doesn't rehabilitate them. And so we need to take an approach going forward that actually seeks to serve the objectives of our criminal justice system, which when you do that will actually help serve the dual cause of decreasing our prison population, and will ultimately, if you address these things realistically, will decrease crime in the long run, will help people have a more complete share of life in general. And so that's, as I said, I spent 7 years working for Tom in the public defender's office. And I always say that now I have a bit of a different objective being in the legislature than servicing the clients that we served in that office. But my approach is very similar in the sense that I think that our objectives of society are served by actually treating people, meeting people as they are and taking them as they are, and helping them. I think there was a mention earlier about focusing more on rehabilitative services. And I don't know how much you want me to talk about going on, but I can tell you that one of my focuses in the legislature, along with Senator Pansy-Brooks, has been increasing access to mental health care, drug treatment, and diversion type programs, actual services within the parole and probation program, which is actually addressing those root causes of why people find themselves in the criminal justice system, and trying to solve or help people solve those problems rather than just incarcerating them for the rest of their lives. I have had the opportunity to visit with some of those folks in the penitentiary that are serving life sentences or the de facto life sentences, 100 years sentences. And I can tell you the exact same thing that Ms. Bailey pointed out, is that those are probably the most thoughtful and gentle people that I have met in the criminal justice system, the people who've spent a long time there, people who, the system did actually have a success in rehabilitating them. Some of those people have been there for a long period of time, which meant that they were in a prison system that actually had more services than our current system has, which is a result of the overcrowding and focusing on, I think, cost cutting and incarcerating. So I think we need to address those things from all of those angles, which is making sure that we are providing services outside of the prison system, but as well as inside the prison system. And then recognizing when people have taken advantage of those services and actually bettered themselves and give them an opportunity to live out in society again. I can keep talking, but I don't want to take up all the time, so I can give it back to Dr. Reese.
Thank you, Senator. We actually have plenty of time, just so everybody who is speaking knows that you can definitely take time. Really excited for all of you and everything that has been said so far. I just want to point out for our audience, if you are not familiar with Miller v. Alabama, it's the 2012 Supreme Court case that's been being referenced in this discussion. And essentially, as the senator mentioned, there were some key words in that decision that the Supreme Court really put out there for us to, talk about children and brain science and development. And that keyword that the senator mentioned is different. Children are different. The Supreme Court, that's what they determined after looking at the brain science. The difference, though, is that if it's under the age of 25, we have this bright red line that we've drawn in our society that says adulthood comes at 18. So if you have a Supreme Court hearing that says children are different and brain development is defined as under the age of, 20, sometimes 26, right? Depending on like the person or the individual, then having a societal bright line that says 18 does not connect to those two things. And so when we bring these cases forward about individuals who are 19, 20, 21, we're really trending in the direction that is in line with the brain science. And so I just want to mention that because in that case too, the other thing the judge has said is that people can change. The resilience, especially among young people, should be recognized. And as the senator mentioned, rewarded too. If you have changed and you are a different person, when do we give people opportunities to come home? Okay, I'll stop. I can continue on forever and ever and ever. I'm going to turn it now over to Attorney Riley.
Well, I can't say much more than what I've already heard from everyone. So I thought what Ashley wanted me to do is give a little bit of a background on how things have developed to where we are. While there are some case law issues that are helpful, the legislative issues are on the opposite end of the spectrum. They're unhelpful. When I first started in 1805, actually, in 1975, the statutes that sentencing provisions were such that the legislature recognized that people can change. And if you had a sentencing statute that said you could get 1 to 50 years, the worst sentence you could get would be 16 2/3 to 50. The law said you could only get 1/3 of the statutory maximum. And that was a legislative recognition that people can be saved or corrected or whatever word you want to use. When I first started, it was called the Nebraska Penal and Correctional Service. Now it's just the Nebraska Penal Service, okay? So we've gotten way away from that. As time went on from the 70s into the 80s, they started introducing things like mandatory minimum sentencing, where you wouldn't get good time. They got rid of the 1/3 maximum on the low end. Don't forget, when you get an indeterminate sentence, you get parole eligible on the bottom end. So if you get 20 to 30 or 50 to 100 or whatever it is, the number of parole eligibility is on the bottom end. And like I said, it used to be you could only get 1/3 of that. So you would always be parole eligible in a reasonable period of time. Well, because of the right-wing cuckoos that run this state, oh, no politics around here, we've changed things. And now what happens is they eliminated that, and you can get, instead of 16 2/3 to 50, 49 to 50. So your parole eligibility becomes almost the same as your mandatory release date, which is totally the opposite of what we're supposed to be doing if we're trying to help people get better, reform, learn how to live in society. It's the exact opposite. right now, what goes on, I go to, and I know Ashley's been to these meetings too with family and friends of the prisoners in Nebraska. And all they talk about is how all the programming has gone down the tubes. You can't get any programming. If you have a lengthy sentence, you aren't eligible. So, and then when you go for parole, they say, well, you didn't complete your requirement of whatever the programming is. Say, well, that's because they wouldn't let me in. So, the prison system is running way too much of what's going on. The politics is running way too much of going on. And, the courts are not doing, at least in Nebraska, aren't doing anything to help the situation. I will say that I'm on a committee now that is investigating the prison overcrowding. Obviously, Governor Ricketts wants to build another huge prison. And as a result of Senator Lathrop's, and probably John can give you a little bit more info on this, Senator Lathrop at least got them to hire a consulting group to give other answers other than building a huge prison. And you know what's going to happen. They're going to say get rid of mandatory minimums, reinstate parole eligibility earlier. And you know what's going to happen in Nebraska. And John, correct me if I'm wrong, but they're going to say, no, we're not going to do that because that's being soft on crime and it's not politically appropriate. So I'm on my soapbox once again, and I've been doing this for too goddamn long. And John, help me out here.
I don't have any correction for you, Tom.
I don't think he's going to save you on this one.
No, you know why? Because it's true.
That is fair. I'm appreciating Alex. Go
If
ahead.
only the sentencing project had data that went back to 1809. I'm so sorry, Tom, that we're not able to trace the entirety of your
Dang.
career.
The first 4 years, me and Davy Crockett,
Well, Attorney Riley, we appreciate your long-term service and commitment to this cause and to this work, and to bring in, go ahead. You want to say?
I was just gonna say, I ain't giving up.
Exactly. And to inject some serious optimism into this conversation, I would love to introduce Attorney Ellis.
Well, first of all, thank you. My sympathies to you, Tom. I certainly know what it's like to toil in fields for years and years without signs of any growth. I spent a little bit of time doing death penalty work in the state of Texas during the heydays of executions, and certainly know what it's like to work in ways that are unrewarded by courts or legislative bodies or the public. So I guess I'm here to tell the happy story of the Curtis Monchke case. But let me kind of start at least what was the beginning for me, because as with any story, it's not simply a story of we showed up, we made the right arguments, and we won. It's a story of learning lessons along the way. And for me, the beginning lesson that was so important was about 15 years ago, being invited and attending what was called the Concerned Lifers Group at the state prison in Monroe, Washington. And this was a group that was working towards making legislative changes, who organized themselves at the prison in Monroe, initially with the resistance of the prison staff there. They had also designed for themselves many rehabilitative programs. And eventually the prison got the idea that it was a good thing for prisoners to do this. So now they have full support. But when I first arrived, and I've attended yearly meetings until COVID for a full decade, what would happen there is individuals would tell their personal stories, stories that reflected trauma, brokenness, great remorse, and trying to come to understanding with their crimes, but also a tremendous amount of rehabilitation, as well as incredibly thoughtful ideas about how to reform the system. In some ways, although these are the voices that are least listened to, they ought to be the voices that are most listened to, because these are the men and women who know how the criminal justice system works and doesn't work better than anybody else. And they were the individuals who started to call for change in the system, who noted that mass incarceration simply wasn't the number of people in prison, but the length of sentences that people were doing. One of the most moving moments for me was a longtime client of mine asked all the men in the room who were over 60 years old to come to the front of the stage. And while 60 ain't that old, 70 in prison is, and 80 is in prison is, and there's actually an individual in Washington State Penitentiary who's 103 years old. And he had the good sense of waiting until everybody got to the stage, which took probably in the neighborhood of 10 minutes, which, you know, no attorney would ever want that much silence, but it spoke volumes about this group that were incarcerating. And so that really set me off on what I call late stage litigation, an effort to try to change some of the excesses of legislative actions that increase sentences and impose life without parole in Washington State for a whole host of crimes. My first attempt to make a change failed. The Washington Supreme Court had decided a very helpful case about late adolescents that said late adolescents share similar neurodevelopment characteristics as juveniles, and for cases not involving mandatory sentences, a judge should be empowered to impose a lesser sentence, a sentence below. Washington has a guideline system, so below the bottom of the range, that it was a circumstance that was mitigating. And so I had argued that this case, recognizing that late adolescents' brain development was mitigating, had changed the law. And in response to that, the Attorney General and the prosecutors of the state of Washington said, if you make that decision, it will impact potentially 10,000 cases in Washington state prisons. And guess what happened? The court got very scared of that. And instead of saying that the law had changed, they said, oh, it's just evolved, but not in a way that anybody who's currently doing a sentence who didn't get that consideration previously can take advantage of it. And so we had to go back to the drawing board and look then at especially the development in the context of sentencing, the Constitution, and juveniles. And the good news out of Washington State is during this period of time, our Supreme Court became much more liberal. And they got good feelings from making good rulings. They struck down the death penalty as unconstitutional in Washington because it discriminated based on race. They applied Miller to sentences less than life. They held that juveniles can never be sentenced to life without parole. They always must have a meaningful chance of relief. And so with those cases as a foundation, we started to look to expand the case law to late adolescence. And earlier, Dr. Reese said the critical phrase from Miller was children are different. And one of the things that we had to decide was whether our focus would be that children are different or that life without parole as a mandatory sentence was different. And so because we were faced with those two options, and in fact, there was some reason to think that arguing life without parole being different may pay off, because when the court had struck down the death penalty, there was a concurring opinion that says Now that we've gotten rid of the death penalty, maybe we need to take a look at some of these life without parole decisions. All right, so then the other thing we had to consider is if you are asking for what the court calls a categorical bar, in other words, you can never impose this punishment ever. There's a test that the court looks at. And one of the things that the court does is it surveys the states to see either legislatively or judicially how many states have imposed this categorical bar already. In other words, what we had to look at in our case was how many states prohibit life without parole for late adolescents convicted of aggravated murder. Well, the short story is those numbers don't look too good. I hope 10 years from now, they'll look a lot better, but the numbers were not in our favor. And so based on that, we said, look, let's not go after the categorical bar. It's probably too early to say life without parole is different. That day will come, and hopefully soon. But let's argue the children are different line and say, but children are not just people who are under 18, because the children are different line is connected to neurodevelopment. So we said, children are different, and so are late adolescents in exactly the same way as children, in exactly the same way that decreases culpability for children. And so that was our focus, was essentially saying 18's not a bright line any place other than in the criminal law, essentially. It's certainly not a bright line in terms of the science and in terms of our medical knowledge. And so you have to expand that doctrine to, in our case, we had two individuals, one 19, one 20, and so the court extended it to age 21. Now, despite the fact that we had a very liberal court that, as I said, had done many good things along the way, Monchke was still 5-4, right? We won by only one vote, which really reinforced to me this idea that our focus on what is called the individualization requirement of the cruel punishment clause. In other words, the fact that you have to take into account this person's background when sentencing. So we're striking down life without parole only because it was mandatory. The decision says a court can still impose life without parole, but it must consider those individualization factors, and it must have the discretion to impose a sentence less than life. What we hope follows from there is what happened in the juvenile cases, right? That we want eventually to get to age 25. We want a restriction on life ever being imposed, but we knew that we had to take this one step at a time. And we then became, as I understand it, the first case in the nation to strike down life without parole for the late adolescent class. Our work's not done. The next move is to move to the legislature next session, see if we can get it up to age 25. If not 25, see if we can get it to age 21. The second thing we want to do, Washington State has been what's called a determinate sentence state, which means there's no parole for most crimes. For juveniles, they instituted parole, and they did something very wise when they instituted parole, which was they said the parole decision has to be made based on risk assessments that are done by a psychologist using instruments which are approved in the field. And the short answer to that is our guys look very good when you use the right instruments. The parole board wasn't always doing it correctly. I represented a young woman who got denied parole, despite the fact that she was an exceptionally low risk, but they just said, oh, your crime's too bad and your sentence is too long, and we're not going to let you out this early. And we had to take that up to the Supreme Court. And ultimately, the Attorney General representing the parole board backed down, and she's free, and the parole board reformed itself. So, you know, you've got to stay on top of all of this. But to me, the lesson of Monchky was don't overreach, figure out what your strongest argument is. And boy, you can just ride this children are different for a long way. Because again, one of the things that we know now is that the differences that reduce culpability for children, categorically speaking, right, for all children, also apply into the early 20s. So there's much work left to be done. There are attacks now against mandatory minimums of 20 years. Washington also has mandatory sentences, sentence increases that come with the use of a firearm, and oftentimes individuals are charged with multiple crimes and multiple firearms, and it's not unusual to have 40, 50 years just of firearm terms. And those are the next things that are under attack. But I think what we've done is laid the groundwork for that next stage litigation. And so it's one of the high accomplishments of my career, very proud to be involved in it. And I think back to those initial meetings I had in the prison at Monroe in Washington with the concerned lifers, who put out this idea that we need to change things, and that the criminal justice system is not serving its needs. So I'm happy to have contributed in a very small way in the Monchky case.
Attorney Ellis, thank you so much for that very thorough layout of your work. Congratulations, a sincere, deep expression of gratitude from all of us. You brought up so many fascinating, interesting points. We have plenty of time, so I'm definitely going to go into a couple of them once we hit on a couple of really important things related to Nebraska, because you mentioned about the case of past cases and the issue of retroactivity. And this is something that I have been learning about Nebraska law there. And I would love to turn the mic over to Attorney Riley to talk about the issue of retroactivity in Nebraska and why it's an issue that needs to be discussed.
Thanks. Yeah, this is a very unsettling situation we have here in Nebraska. We used to have a statute that is similar to what is present in both federal court and in many states, which allowed a sentencing court after the original sentence was imposed to reduce the sentence of the defendant that he or she sentenced. It made a lot of sense. I don't think our statute at that time went far enough because you had to do it within 120 days. I think what's really more important is statutes that show a person after 7, 8, 9, 10 years in prison has changed, shouldn't have to wait another 10 years to be eligible for parole, okay? So the statute that was passed in Nebraska or was in effect in Nebraska said 120 days after the sentence is final, the sentencing court could reduce the sentence. Unfortunately, well, it was done in a case, and the Attorney General at that time, Don Stenberg, filed an action saying that the way Nebraska Constitution was set up was that the only entity that could reduce the sentence was the executive branch, which in Nebraska isn't governmental, or I'm sorry, governor pardons. It was a pardon board that consists of, get this, the governor, the Attorney General, and the Secretary of State. So the Nebraska Supreme Court agreed with the Attorney General and said that the judiciary had no authority to reduce the sentence. Only the executive branch could do so. As a result of that, the only way we can get sentence reductions to occur is to pass a constitutional amendment, because it was done under the state constitution, not under the federal constitution. Now, Are there possibilities of arguing Eighth Amendment issues, et cetera? Maybe yes, but I'm not optimistic. There have been efforts recently to introduce a constitutional amendment to change the Constitution to allow judges to reduce sentences in appropriate cases, and they have not. Those actions have gotten basically nowhere. Once again, we're in a bright red state that does not have a judiciary that is progressive. We do not have a legislature that has a majority or even a close to a majority of senators who would be willing to do something about this. So it's a very, very unsettling situation. I'm very unhappy with the fact that people that are doing huge, we have way too many people doing ridiculously long sentences on just the types of offenses that other people were talking about. I'm not answering that, by the way. That are doing ridiculously long sentences, who have no chance for parole, even though they have been rehabilitated decades before their eligibility. I was lucky enough, as Mr. Ellis was saying earlier, to me, my greatest accomplishment as a public defender in the last 40-something years is under Miller. We got some resentencing, and I had 13 clients, and 4 of them are out of prison. Now, it was not because of me, it was because of how they conducted themselves in prison during the 20, 30, 40 years they were there. But we were at least able to present that to a court and say, you don't have to keep these people here any longer. They are not a threat to society. As a matter of fact, many of them are an asset to society. They have plenty to contribute, and I know Ashley knows some of them, and I know a number of them, and it's so absurd to think that we have a constitution in Nebraska that prevents a judge from re-examining a sentence that was way too harsh when it was initially pronounced. And so many of them were kids that were between the age of 16 and 23, 24, 25. So all the things that everyone here has been talking about is germane, and God damn it, we're right about it. And I just wish we could get people to listen to what we have to say. So, right into the slide, you know.
Thank you so much, Attorney Riley. You are obviously in need, given the time of night it is and your phone call ringing. Miss Bailey, you are chomping at the bit. Lay it on us.
I am. I'm sorry. I have to jump in here.
Do it.
Because
the floor is yours.
To Attorney Riley's point, there's a capriciousness about how different states are enacting their laws, right? So as he just pointed out, in Nebraska, they decided that if you wanted to get out of prison, that required the governor, the attorney general, and the secretary of state, right? The judiciary does not have the authority to alter the sentences that they ultimately handed down. Then you can take a state like Pennsylvania that has the Sutley law, whereby the legislature cannot change a judicial decision, right? So very often we're just seeing a level of caprice that really has much more to do with a desire to be punitive, based on racism, poverty, and a whole host of other factors, rather than really sort of looking at what we know to be true in terms of the research. While I'm certainly not as colorful as Mr. Riley there, I will say that, yes, I mean, we are correct. Nationally renowned criminologists have shown that 10 years is more than enough. But we're watching states do this differently depending on the power structure that they want in order to keep people in prison, with no standardization about how we're handling this. And what we're seeing is a detrimental effect no matter which path that they're taking. So we really have to start basing our legislation in fact and what we know to be scientifically true. Soft on crime is a complete and utter misnomer. We need fact-based responses. And if we are going based on the facts, based on the brain science, then 10 years is enough. You should be allowed to be reviewed at that point. 15 years for adult at a maximum, 20 years is an absolute cap, because you are taking what is a limited deterrent that is highly costly in terms of dollar and people, and applying it across the board with a level of caprice state to state that frankly, I personally find shocking.
Let me add one thing as far as Nebraska goes. Ashley wanted to talk about LB 34, which is Patty Panthing-Brooks' Sentencing Reformation Act, shall we call it. And we do have the authority legislatively to make the sentence reductions retroactive. So if the legislature were so inclined, and Patty's Senator Panthing-Brooks bill passed with the sentence reductions, with an additional clause in it that says this shall apply retroactively to people who are serving these sentences, it would pass, in my opinion, would pass muster. Now, once again, I will refrain from my colorful context about politics, but you know where I'm coming from. And it's an uphill climb, but it's doable if you get the right people to do it. I don't have any faith in the courts right now in their current makeup. And once again, I don't mean to throw cold water on this. I'm just trying to be a realist when it comes to Nebraska.
Thank you, Attorney Riley. Of course, no, we need a balance in all things, absolutely. So thank you for that perspective, and thank you, Ms. Bailey, for your passion. With you all the way. Senator Cavanaugh, I can't help but ask, do you have thoughts? Would you like to weigh in?
I would like to weigh in, and I would just point out I'm probably the least colorful person in terms of my rhetorical style, but some people see that as a virtue. But kind of what everybody has been saying has made me think, so we've talked about this issue of the retroactivity before, and I've talked to some folks about it, and it is an uphill climb to enact retroactivity. However, as Mr. Ellis kind of pointed out, a lot of these reforms need to be taken in bites, smaller bites. And so a prospective change in the law is a smaller bite that is a proof of concept that then we can start to push the other issues. And so Tom is right that ultimately it's the judiciary, but it's a political question. Judges are political because they're afraid of looking soft on crime. They're afraid of, our judges in Nebraska are not elected, but they are retained. And despite the fact that if you pay attention, no judge has gotten below 80% retention, they all are afraid of that newspaper article that says that they let somebody out who went on and did something terrible. And so they have that in the back of their mind when they are doing these sentences. And so while judicial discretion, it can be helpful in terms of creating a more equitable system, it can also create the system where people get a 49 to 50 when we give them too much discretion. And so as the legislature, we need to find that balance that sort of takes that out of their hands and puts it more into the what is going to make a more equitable system and make things actually reflect what they should. And so I guess that's two parts of that question is, and then of course the pardons board, as Tom pointed out, are all statewide elected Republicans in the state of Nebraska, and have been. The last time a Democrat won one of those statewide offices was 1994. And so, and any of the other offices was longer ago than that. And so it's definitely a political question, and making justice political is not healthy. It's not constructive. It doesn't serve the objectives of the system. And so finding ways that we can depoliticize the justice system is important. But that is, I mean, that's a much bigger thing. We have to make structural changes to just how we approach criminal justice. But when it comes to these sorts of reforms, and actually, so we could talk about a whole lot of other reforms, and we're focusing on this one tonight. I don't know if that's the nature of the panel or not, but so when it comes to juvenile sentencings, we need to, as Tom said, we're right about this. And so we need to just fix to what is the right thing that we can get accomplished and start working towards that. And then once we accomplish that, we start working towards the next thing that's right, as Mr. Ellis pointed out. And so that's the charge of people like myself and Senator Pansing Brooks and whoever else comes after us or comes with us in the legislature, to keep working to fix the system as it stands today. And we have some opportunities going forward, and we have made some small reforms, and I'm hopeful that in my next I've got 3 years left of this term. My next 3 years, we will see some of that progress. So it's unfortunate that it's political, and it's unfortunate that people don't do what they think is right, whether it's judges or the governor and the pardons board, because they want to look tough on crime. But that's the system we have, and we have to start working within that system to fix it. So that's, I guess, what I have to say about that.
I think the record should reflect that he said, "Damn it, we're right."
I noticed that, and I was gonna comment.
I never, my vocabulary is never going to be as colorful as Tom Riley's.
I love it. I love it. Now, Senator, thank you so much, because the politicization of many of our systems in this country is actually really problematic, as Miss Bailey pointed out. When we go with the evidence, when we go with the research, and so when we have these conversations, part of the point of the conversation is to educate everyone in our country who knows nothing about criminal justice or the prison system. They assume that if we are keeping people locked up for the rest of their lives, it is because they are dangerous. And I can understand why people have come to that conclusion. They're assuming that if you've gone into prison and you've done something, it means that that you need to stay there and that you're a danger to society. And we have these conversations now because we are here to tell you that it is all political. It's very rarely actually utilizing any sort of evidence, research, science. In fact, thank you so much, Attorney Ellis, for talking about Washington and the parole board. I actually didn't know that that's a rare thing, because I have watched mentors of mine who are forensic psychologists who are highly respected and sought after testify time and time and time again in front of parole boards, literally to have the parole board ignore their recommendation and just, pass it off as if it was done without any sort of evidence-based risk assessment or anything like that. And so thank you. And would you like to respond to that, Attorney Ellis?
Yeah, thanks. I mean, Washington had parole until about 1984, and then we abolished it until it started to get reinstituted with the juvenile cases. And the previous parole statute was basically a statute that says let them out if you want and not if you don't. And there wasn't any requirement of any risk assessment considerations. It was just more that sort of intuitive thing. In fact, there's some really old Washington opinions that said, of course, parole board officers have developed this intuitive skill that allows them to look into your soul and determine whether you're going to commit a future crime. And that was fine for the reviewing courts. But luckily, when the statute was passed post Miller, it basically said, look, we need to take a look at risk assessment because, as been pointed out already, these individuals are among the lowest risk assessment individuals. And even then, the first parole hearings were hearings where they were only using what are called static risk assessments. In other words, they only looked at historical factors. So, have you been in a stable romantic relationship for over 5 years? Well, the answer for somebody who fell when they were 16 is probably almost always going to be no, because they were arrested before those romantic relationships began. But luckily, like I said, with a lot of pressure on the ISRB, we eventually turned that around. And now when I appear at parole hearings, I constantly remind them that the other individuals that they let out are doing well, because I want them to know that they're making the right decisions and that release is good. If I can add to also about the opportunity, as difficult as it might be in Nebraska through the governor's power of commutation or pardon. You know, one of the precursors, I think, in Washington State to Monchke was actually having individuals who Washington passed this 3-strike law, which was one of before we became good, we were really bad. Like, we were the state that reinstituted 3 strikes. We were the state that put sex offenders in other prisons for treatment under the sex predator law. We had a good decade plus run of trying to be the most punitive state in the nation, and largely succeeded at that. And you know, a good 20 years in, some of the 3 strikers who fell on second-degree robbery, which in Washington State is simply taking property from another person without a weapon, without injuring them, but with some threat. Those individuals who had done really well, we started looking at them to bring clemency petitions. And I was happy to be involved in the very first case. And I decided that I would approach the prosecutor to see if the prosecutor would agree. Luckily, in the meantime, the former prosecutor had passed on, and there was a new prosecutor who was trying out his liberal wings, and decided that this would be a good case to start with. And he said to me, well, you know, one of the things I'd like to do is I'd like John Carlson to meet with your client. Now, John Carlson was the right-wing radio host who passed the 3-strike law. And I said, why would you ever think that I would do that? And he said, well, because if he's on your side, you're not going to lose. And so we took a chance, and John Carlson and the King County prosecutor and I went to the prison in Monroe, and Carlson realized my client was a human being, realized that he had done many good things. And so when he showed up at the clemency commutation hearing, John Carlson spoke in favor of our client's release. That then started a number of guys who had struck out being released. Eventually, I got tired. As wonderful as it is to get one guy at a time doesn't undo mass incarceration. And so, and in the meantime, a nonprofit group called the Clemency Project had sprung up in Washington and started focusing on that. So I started turning my attention back to the courts. But it, you know, again, it was one of those things where initially that's not where things were happening. But we eventually turned that table and created this dynamic of individuals who'd been doing life being released that I think then got some both legislative attention as well as the attention of the judiciary.
Thank you so much, Attorney Ellis. And I just want to remind everyone that we will have a future webinar coming up about parole. So we'll be able to continue this conversation in that panel discussion. Thank you, everybody. I wanted to say a quick thank you to our people who have popped in Q&A questions and things in the chat and comments in the chat. Before we jump over to that, I want to just turn the floor over to Jason Whitmer, who's from stand-in from Nebraska, to offer some additional comments.
Yeah, can you hear me with these headphones?
We can.
Okay. Yeah, so I have quite a bit of personal experience inside the prison system, not as an employee, just as a product. With that said, so there's a few things were said, and I wasn't keeping notes because so many great things have been said here today, so I definitely lost track of some of them. But I wanted to say one, since we're speaking of Nebraska, I believe, and I could be a year older, that our youngest life sentence was given to a 14-year-old. I believe there was 2 of them. One perhaps was 13. I know one personally, so that's the only one I know names. However, Miller Act has helped him, and he's successfully employed and doing well. You know, he has his little ways of behaving that people are like, hey, what's wrong with him? But can you imagine 14 and 30 years in prison? A 14-year-old doesn't even have the experience of a 17-year-old. The difference between them 3 years is huge. It does not justify what happens to a 17-year-old in this case. But what I'm saying is that's the audacity of our state, is to think that anything a 14-year-old does, a 16-year-old does, means the end of his life inside of a prison system. Somebody said something on Facebook that I would like to just put out. So they was talking about reform in the system, people change and, and whatnot, and how the system points that out as a person who has done so much better because of what we've done. And often I think some of us come out and we agree with that statement because we're thinking in terms of this time I sat in there, they gave me a chance to change. And we're not talking about children here when I say this, but I'm still going to refer to children as that is like saying, I will put you in the closet for a week. And because you don't do this, or because you're reflecting that somehow this has contributed to your change of behavior. Whereas what I've seen, and this goes back to what many of you said, because this affected me because I was one of the more wild ones. And I mean, sometimes it was at extreme level that I became pretty notorious in the system, if that's what you want to say. And the greatest changes in my life that came in there was from men who had resisted the system to educate themselves. And in that education came what they call critical thinking, meaning they didn't just change their behaviors and some of their thoughts, but they actually thought about why they are and why I have this thinking and them elements. And that was kind of the thing they passed to other ones of us. I will relate it to, in a sense, to what peer support is imitating, even if they don't know it. The intentional peer support is imitating, is the men weren't in there preaching to you, change or you're damned. They was talking to you like a human being while they was introducing things, and they was creating a relationship with you where you didn't have to feel so far down below them in order to come to the same level. You felt like you was almost on the same level, even though some of them were like scholars by then. Some of them were doing so much better with themselves. And most all of them in my life were doing life sentences plus 50 years, 150 years of stacked sentences, which is what you call, I can't think of the terminology right now, but essentially it's a life sentence in numbers, all of that. And so to think that we can't reform sentencing and that would come out beneficial to all society is a ridiculous notion. And as was stated, like why is arbitrary behavior, arbitrary thinking, the rule of measure of what I'm gonna pass sentences on? Here's all these rules we got when we show you why we pass sentences, but ultimately it is passed on arbitrary thinking, just like parole is arbitrary and discretionary thinking, and just like the pardons board, who I recently seen, and then at the end spoke on a case that everybody in the state knows is an innocent case, speaking of Ernest Jackson. And they all nodded their head, and Attorney General even said he would look into it, and nothing has come from this. Because, as was said again, it's a political system. If the most voting people believe that you need to go hard on crime, the majority of the politics that are when they're ruling on what we should do or not do is going to fall on the side of making sure that mass amount of voters is on my team when it comes my turn to get voted in again. Make sure I know I'm on this side of the fence. And a lot of them senators that are talking that haven't even gone into the system to check out what's happening in there. Somebody asked some things to do, and I know we're going to introduce this at the end, is, first of all, support the senators who actually use their brain themselves. It is not dictated by the politics of the people. It should be dictated by the people, but not the politics of the people, if that makes sense. That's what we're battling right now. Politics is saying you're either on one side or another, and there's no such thing as a middle ground where it shows you this is not right for people. So we need to handle this. But to support those individuals who are doing that, if somebody's not doing it, like Ricketts, make sure that sticks to his record, because he's going to try to move up higher, which means he's going to get more grounds to do things. even worse. And remember, Ricketts is a pro-life guy and a pro-death penalty guy. That doesn't make sense. He's a pro-choice, he's taken away pro-choice, yet he's an anti-vaccine guy, which is vaccine is a pro-choice, whether we like it or not. I'm just saying that everything's contradicting, which means even those who feel like he's on your side cannot trust him. Pete Ricketts. At some point, I would like us to talk about lobbying. I don't know if that's a thing, but we was talking about sentencing reform, and we was talking about, and then the Senate legislation, Ernest Jackson bill went up there, and the senator who put it forth acknowledged Ernest Jackson is innocent. This is not about Ernest Jackson right now. I'm just using this case in the sense of what they're doing with their leadership. He acknowledged that this is terrible. This man is innocent. However, if I was to let this bill, Ernest Jackson bill, be amended to my bill, I was told by the county attorney's office and the attorney general's office that my bill would die. So a senator is acknowledging on the record that these offices say, we not only do we not agree with this, we will make sure your bill dies, as opposed to just putting in an objection. And I have never heard nothing about some uprising of how can this be controlled. So I think Riley pretty much has it on point, not to call you out, you know, and several others is Tom, sorry. But we got Don Klein in office. We got Katie Benson. These are individuals I'm naming because I've listened to them sit there and say, if we do this retroactively, how many guys will come forth and say they're innocent? How many guys will come forth and say this testimony? And that is our thinking. I want you to worry about, if we have this sentencing reform, how many men might get out? How many women might get out? They'll flood your, wouldn't that be an indication on our system and those who are putting it together? If we push something in for, put something in place and a ton of people get out on some, that's, what was you doing wrong in the first place? What was being done wrong in the first place? So speaking from, just to stop what my going on, from personal experience, the greatest reform in my life inside the prison system was not the people who said, follow the rules, just do the program and keep your head low and get out. They tended to come back. It was the people in there and then the people who started listening. But it started with the guys in there that said, no matter what my future looks like, I'm doing this with myself, I'm educating myself, I'm using critical thinking. That means when somebody comes with a different viewpoint than mine, I'm not going to reject it firsthand. I'm going to, I'm going to look at where I'm at. I'm going to look at where they're at and try to make an intelligent decision. And I think that element right there, everybody on this panel and everybody we speak to, that will be the greatest element in change, is the willingness to look at your viewpoint and somebody else's viewpoint and do what's best for everybody, no matter whose side you're on.
Jason, let me, as you and I've had several discussions and we agree on pretty much everything. But one of the things that Jason said that I think is really, really important and needs to be focused on is his pointing out that sentencing is a kind of discretionary thing. And a judge that sentences someone when they're 15 exercises their discretion. Maybe we agree with it, maybe we don't. But maybe it's a good idea to allow someone 10 years later to also exercise their discretion with the additional information they have as to this person's growth. And I totally agree with Jason. From my experience and talking to guys that are in the same situation he's been in and that I've been had the pleasure of being exposed to, they're the ones that, like I said, I didn't get them out. They got themselves out. All I did was present the information that they gave me. And he's 1000% right. But the discretion point is so true. I'm all for discretion with judges. I don't really like the idea that mandatory minimums. I agree that there should be a cap on how harsh they can be. There shouldn't be a cap on how, I can't give this person probation because they have a mandatory minimum. That's BS. But I think if discretion is what we're going to look for, it should be reviewed over a period of time with another set of eyes. How many times in our own lives have we said, you know, I want someone else to take a look at this. I've looked at it and I've come to this conclusion, but maybe another set of eyes will give me a different viewpoint. And I think that's, you know, that's the ideal we should be looking for, is that once a sentence is imposed, should not be the end of it. We should be able to review these things without these phony constitutional BS excuses to keep people in prison for longer than they should be there. And once again, I'm being too colorful. I'm sorry.
No, don't. Oh my gosh, never too colorful. I just want to say thank you to Jason. You had people, popping in the chat, just really resonating with what you were saying. Once again, that personal experience, right? These are human beings that we were talking about. And from everything that everyone tonight has said, really like that, I hope that that's like front and center, that these are human beings that we are talking about, that this is the beginning of a conversation in many ways, that we have to keep going and take this in chunks, as our very wise people in the space have named and talked about. We do have just a few minutes left. And so I want to make sure that we get to the couple of questions and comments that we have had from our wonderful audience tonight. And so first, I'm going to start with Teddy, who asked, how are they able to charge youths as adults, even if they were under 18, 19 years old? That does not seem fair and makes no sense. And so the first question I'm going to ask is if somebody could clarify, does Nebraska have a mandatory transfer law or just an ability to transfer juveniles to adults? And then maybe someone could comment on Teddy's question about charging youths as adults. I'll open it to the floor.
Yeah, well, the Nebraska law allows prosecutors to charge people as adults. I'm not going to get into all the nuance of it, but by and large, it's a prosecutorial discretion thing. There are a few points where they have to file you as a juvenile. There was some legislative movement requiring that in certain cases, they had to file it in juvenile court, and then the prosecutor could ask it to be removed to adult court. Typically what happens is in serious cases, they'll file it in adult court and we have to make a motion to transfer the case to juvenile court. We have a right to appeal that if it's denied. And by and large, when it comes to serious cases, and cases like Jason's talking about 14, 15, 16-year-old kids charged with homicides, for the most part, especially if you're white, unless you're white, it stayed in adult court. If you're white, sometimes it all of a sudden gets transferred to juvenile court, and maybe that's the topic for another day, but I can cite a couple of cases where it turns my stomach.
Definitely a very important topic for another day, where the evidence shows that actually when a person is white and committed a crime, we are more likely as a society to take their context into the situation and if it's a person of color, we attribute that to an individual level of dangerousness. So Amanda asked, is there a reason that judges do not use large sums of restitution versus X number of years for a sentence? I honestly believe that it would be a far worse punishment if punishment is the goal. Would anyone like to, and I open the floor for anybody's response to that question.
I want to say something on that. I'm not one of the experts, but
Yes, you are.
it sounds great. And when I first read it, it sounds great, but we forget the element of poverty and crime.
Correct.
And the drastic, they will put you in such poverty, especially somebody that's already on the brink of struggling with, getting on this side of things and this on the thing, that I can't see it not pulling more people under, let alone it's not even a college degree where you can at least pretend like that bill that college puts on you to drown you, that you got this great job from it and maybe you'll get your way out. We're not even at that stage. So it could put a $25,000 fine on a family, could destroy the whole family.
Correct.
For years, if not getting out from under that. And who knows where different family members end up falling in line and right into this pipeline. So That's where I see that being a negative.
Thank you. Ms. Bailey?
Yeah, I got to jump in here on this because restitution is also something that we use to keep people from other rights, such as voting. And it is a way to extend sentences, even once you have served the time that you were given under your sentence. And I think, Mr. Whitmer makes the excellent point that so much of crime comes out of poverty. It comes from dual victimhood, where, somebody is deprived of the things that they need, and that deprivation plays itself out. But this is actually one of the tools that we have kept to keep people from their voting rights, and very specifically in the Midwestern states. So I think we have to be very careful about the concept of restitution. It plays out in a lot of spaces beyond sentencing.
I completely agree. And when we go to the evidence, there's a lot of evidence that points to that at least half, in many states more, at least half of our incarcerated population come from below the federally defined poverty line, which is $26,000 for a family of four. So imagine $26,000 a year for a family of four, and then being hit with, as Mr. Whitmer mentioned, a $25,000 fine. But Ms. Bailey.
Well,
Oh,
go ahead.
I'm going to go Ms. Bailey and then Attorney Riley.
Just real quick, last point, because somebody asked in the chat, if people are sentenced to restitution, they lose their right to vote. Now, in some states, you just lose your right to vote permanently. But in some states, you cannot have your voting rights restored until you are done paying restitution. So that is basically also a de facto life sentence on your fundamental right as an American citizen to be able to exercise your right to vote. So it is another way that we keep people who have served time out of society, even though, on a tangent here, allowing people to re-engage in the political system actually helps rehabilitation and keeps down recidivism. So my last thing, and then thank you, Sue, for saying that, yes, some states will reincarcerate you if you miss a payment on restitution. So again, these are all ways that we continue to keep people sucked into the system.
Absolutely. Great points. Attorney Riley?
Yeah.
Oh, you muted yourself.
Sorry. The only thing I was going to say is on a much more visceral level, prosecutors, especially in, high-grade misdemeanors, will say, hey, if you'll pay restitution, we'll drop the charges or we'll drop it down to this or that. Well, just what Jason and Alec are saying, if you don't have any money, they're shoplifting food, they're shoplifting clothing. And they say, well, pay back the restitution. Well, they can't do it. So if you were doing that and had wherewithal, you get out of the criminal charges and you don't face the kind of consequences that Jason and Alex are talking about. Whereas if you're the client of our office, they don't have any money in the first place. That's why they're appointed for us to represent them and saying, okay, pay off the restitution and the case will go away. Well, that's a non-starter. I mean, we don't have the money, our folks, so they sit in jail and they have to plead and they have, to have another criminal offense on their record, many of which are enhanceable on these, what some folks would call 3 strikes, but I'll just call them enhanceable offenses that turn misdemeanors into felonies.
Correct. And Linda made a comment in the chat I just want to mention where she said, we need more options for sentencing, not just time, but treatment, counseling, home restraint, or we would say like home confinement, or like doing, your sentence, like being at your house. And this is why we're having this conversation. So in the last couple of minutes, as we wind down and we wrap up, I just want to turn the floor over to Senator Cavanaugh for some closing remarks, and then we can hear from Attorney Ellis, and we'll wrap up tonight.
Well, I don't have any specific closing remarks. I just would echo what everybody was saying about the first thing that occurred to me when thinking about large sums of money is that it's strictly punitive and it doesn't serve any rehabilitative purpose. And so it doesn't actually serve the cause of decreasing crime. It's just sort of an alternative punishment. And so I agree. I think we should focus on all of the options that will help people not find themselves in the situation where they're shoplifting food or using substances or other types of crimes that people are committing, that we can and we know how to help people. And so that's where I'd like to see us focus on in the criminal justice system. And of course, if we start helping people at juvenile level and earlier, that before they find themselves in the criminal justice system, that is real criminal justice reform. That's how we're actually going to help people. That's how we're going to decrease crime. That's how we're going to decrease overcrowding in our prisons. That's how we're going to solve the issues systemically. I appreciate the conversation here. It was really great to hear everybody's perspective and be part of this. And I hope to learn more in the future. And it was great to hear from especially folks outside of Nebraska that I haven't heard those stories before. So I hope to hear from you more in the future. But thanks for having me, and we'll see you next time.
Thank you so much, Senator. Attorney Ellis?
Thanks. I guess I would say a couple things. First of all, keep hope alive. Martin Luther King Jr. said that the arc of the moral universe is long, but it bends towards justice. I was able to share the experience in Washington State, which as I said, for a decade plus was among the most punitive states in the nation. And really through good work of people in prison, and then them bringing those stories to the executive, to the legislature, to the judiciary, things have changed such that we now have the first decision in the nation saying life without parole cannot be imposed mandatorily on a late adolescent. But of course, the arc doesn't bend towards justice on its own. So there's a lot of hard work, a lot of failed opportunities along the way, but persistence pays off in the end. And so I commend you for the work that you're already doing, and I wish you the best of luck and Godspeed for the work that's to come tomorrow and tomorrow and tomorrow.
Thank you so much, Attorney Ellis, Senator Cavanaugh, Attorney Riley, Ms. Bailey, and our de facto panel expert joiner, Jason Whitmere. Thank you so much for chiming in. Thank you to everyone who attended this discussion. Again, it's just the beginning. Join us for our future panel discussions. We can't wait to have you come with your questions, come with your thoughts. And thank you all for your time this evening.
Thank you. Thank you for the invitation.
Thank you.
Thanks, everyone.